So when does a power of attorney expire? My name is Andrew Ayers. I'm an estate planning and business law attorney with offices in Edina, Minnesota and New York City. Today let's look at powers of attorney and when they expire. So it's a pretty common question I get when people have a power of attorney, and it's how long is this document going to last? And that question is actually not even limited to your power of attorney. It could be any kind of estate planning document. We create them at some point, you spend some time, you create your legacy, you put everything together, and you wonder, does this have an expiration date? Does it just go on forever? What happens? And in many cases, the documents you sign do not have expiration dates. So it's very common for me to meet with people who have wills that were prepared 15, 20, 30 years ago. Their kids were little, they have guardianship provisions, now everybody's grown up, maybe there's grandchildren involved. Those documents are actually still valid all these years later. It doesn't automatically expire. However, when we're looking at our estate planning documents, we need to draw kind of a line in the sand and figure out the pre-death documents and the post-death documents. Because actually, when you die, that does create a cutoff for many of the documents you deal with. So when we're first looking at powers of attorney, with things like HIPPA authorizations, things like a living will, these are what we consider pre-death documents, meaning these documents have power while you are still alive. The power of attorney says, I'm giving my financial power to somebody to make decisions for me if I become incapacitated, or I'm just giving someone a power to do a real estate transaction because I can't be in the state on the date that we have to do that transaction. So a power of attorney is going to be for big decisions, or they can be little decisions that you need to make when you can't be there, whether you're incapacitated or just not physically there. Same holds true on the healthcare side of things. So a healthcare directive, a healthcare power of attorney, we're designating somebody to make healthcare decisions for us when we are unable to do so. If you have a living will, that living will is designed to say what happens if you end up in a vegetative state and whether or not you want them to revive you or not. So those are really the pre-death documents that we look at. And then we're going to switch to the post-death documents. These documents are actually going to be your will and your personal property memorandum. What these documents do is say, after you're gone, here's what happens to my estate. Here's what happens to my assets. Here's who I'd like to be the guardian for my children. Here's who will be the trustee to manage the money on behalf of the children. The point is that will is there to lay out what you'd like your estate to look like after you're gone. The personal property memorandum is something we commonly use for smaller items like baseball card collections, grandma's china, things like that we want to pass along to certain people in our family. So we've looked at before death and after death. There's actually two documents that can actually bridge death. And it's very interesting the way those work. The first would be our HIPPA authorization. So whenever you go to the doctor, you're filling out all those forms in the waiting room. You've got the clipboard, check, 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 sign here, check there, sign here, check there. Or maybe it's done online these days. You go to a website and electronically fill them out. One of those documents is normally a HIPAA authorization. It governs the access to your medical records and says who can see them. If we use a HIPAA authorization as part of your estate plan, that is usually given to the person who is operating under your healthcare directive or your healthcare power of attorney so they can see your medical records to make decisions. Now, one little trick to a HIPAA authorization that's different than a power of attorney is that your HIPAA authorization can survive your death. So oftentimes when I draft a HIPAA authorization, it will survive for 2 years after somebody dies. The reason is we want to make sure we have access to those medical records in case there was anything fishy about the way that you died, especially if you were in a hospital and we had concerns about medical malpractice or other concerns about what was done. We want to make sure that we are giving your estate, your personal representative, or your executor access to the medical records to find out what really happened. The other document that we commonly use that will bridge life and death is a trust. And so in this case, we're using a living trust, which is a document we set up during your life. So while you're still alive, we can move assets in and out of that trust. We can have various provisions. We can have special needs trusts, supplemental needs trusts, all kinds of different reasons for creating that trust. And we can set it up during our lifetime, and it can still go on after you're gone. So even after you die, that trust can still have provisions that allow for your business to be run by your trustee. We can have distributions going to children and grandchildren long after you're dead. So that trust will actually be one of those bridge documents from pre-death to post-death. Now, this video is going to be a little too short to go into all the different reasons why you would or would not want a trust. So that's one of those questions you want to make sure you talk to your estate planning attorney about whether or not a trust-based plan makes sense for you. And that trust can be set up before you're dead, or it can actually be put in your will, called a testamentary trust, in which case that trust is a post-death trust and only gets formed after you're gone. So back to our original topic, those powers of attorney, and when do they expire? And the simple answer is they expire when you do. So when you die, your power of attorney also expires. Now, this is a very common situation I run into with family members who have a power of attorney and then their loved one dies, and the person with the power of attorney tries to keep making decisions. And the fact is, legally, that's not correct. Once that person died, the power of attorney expires. They have no power to continue to make financial decisions. At that time, the person who takes over is the executor or the personal representative under the person's will. We look to the estate plan documents, those post-death documents, to see who should be in charge once somebody dies. But it's very common that somebody who has power of attorney just assumes my power of attorney will last, and even after mom is gone, I still get to make those decisions. But you need to understand that that power of attorney expires, and if you're not the personal representative and you're not the executor, you could be getting yourself in some legal trouble. You could be legally responsible if you keep trying to make financial decisions for your dead loved one after they're dead and that power of attorney has expired. If you have more questions, you'd like to set up a legal strategy session, you can go to my website, andrewmayers.com. There's a red legal strategy session button on the front page. Click that and you'll be taken to my personal calendar. We'll set up a 15 or 20 minute phone call to discuss powers of attorney, your estate plan, whatever other questions you may have. If you like this video, you can hit the thumbs up or the like button below. You can subscribe on YouTube or going to ayerslawtv.com. And you need to remember, if you have a power of attorney, you have a healthcare power of attorney or a financial one, they do expire upon death. And if that person has died, you don't necessarily have the power to keep making decisions after they're gone.